Hello friends, welcome to my channel. This is Mayank Shah, practicing company secretary based on Ahmedabad. Let's move forward with our continued subject, that is jurisdiction of the tribunal under the Companies Act, manner of application under the NCLT rules and case laws. In my earlier videos, we have gone through tape to date section 7, section 48, section 55, 58, 59, 61, 62, 71, 9, 71, 10, 73, 74, 76, 90, 119, 97, 98, 130, 131. Then another section where the jurisdiction of the tribunal vested is section 140. 140 in which both two subsections where the jurisdiction of the tribunal vested, that is 140 subsection 4, 140 subsection 5. In section 140 subsection 4, it prescribes that, it states that wherever the company wants to move for a resolution, two types of resolution. First, appoint a person other than retiring auditor where his term is not expired under section and when the auditor is appointed under section 139(2). Second, wants to pass a resolution express resolving that not to reappoint the retiring auditor. Then in such a cases, what will be the procedure that has been prescribed, in which the special notice what has been prescribed. And wherever the word special notice prescribed, section 115 comes into mind. 115 प्रोसीजर ये रहेगी कि मिनिमम नंबर ऑफ मेंबर कौन से, तो 115 में प्रिस्क्राइब है कि मेंबर्स वर होल्डिंग 1% ऑफ द टोटल वोटिंग पावर और मेंबर्स होल्डिंग द शेयर्स ऑन विच पेड अप शेयर कैपिटल 5 lakh rupees has been paid up. Such members issue the special notice, serve the special notice to the company that they want to move the resolution, either of the resolution. In turn, company send this said special notice to the retiring auditor, and in response to which the retiring auditor prepare the representation his and request the company to circulate amongst the members. So यहाँ पर टाइम लिमिट क्या है? टाइम लिमिट का, if the reasonable time is there, company needs to require to serve amongst the member. If no reasonable time is there, then in such a cases the opportunity has been given to the auditor to read out the said representation at orally at the meeting. Now, the time limit to serve this special notice by the members to the company is not earlier than 3 months and not at least 14 days prior. So 14 days prior नोटिस सर्व किया, नोटिस सर्व करने के बाद कंपनी ने इंटर्न ऑडिटर को दिया, ऑडिटर हम अगर कंपनी को देता है रिक्वेस्ट करता है सर्कुलेट करे तो 7 दिन बाकी होते हैं तो सर्कुलेट कर सकती है. 7 दिन नहीं बाकी है, इम्पॉसिबल है सर्कुलेट करना, तो इन दैट केस कंपनी राइट दिया जाता है ऑडिटर को टू रीड आउट दिस सेड रिप्रेजेंटेशन एट द मीटिंग. नाउ अगर कंपनी चाहती है, अगर कोई भी अग्रीड पर्सन चाहता है कि सर्कुलेट रिप्रेजेंटेशन सर्कुलेट नहीं किया जाए, या तो फिर ऑडिटर को राइट नया दिया जाए कि टू रीड आउट द रिप्रेजेंटेशन ओरली एट द मीटिंग, देन इन सच सर्कमस्टेंसेस कंपनी और अग्रीड पर्सन may make an application to the tribunal, and the tribunal, after hearing the parties and after going through the documents on the basis of which the aggrieved company and aggrieved party wants to get the relief not to circulate the representation and not to read out the representation orally, after going through such evidences, pass an order and restrict the auditor not to direct the company not to circulate and restrict the auditor not to read out the representation orally at the meeting. Now, the manner of application, in which here the one point is there also. If the company is not circulate because of time constraint, company is not in a position to circulate the said representation amongst the member, then in such a cases company needs to require to also serve the said representation copy to the ROC. The manner of application in which the application made, that is NCLT 1, it has been prescribed under Rule 78 of the NCLT Rules 2016. The supporting annexure NCLT 1 is that in this case registration document of the company, if the company is making application on behalf of the company director make an application registration document, then the evidencing on the basis of which you are praying that for the direction not to restrict the company not to circulate and restrict the auditor not to read out the representation orally. So the copy of representation and copy of evidence document proof. Now the application can also be made by the aggrieved auditor. Yes, if no sufficient opportunity has been given to the auditor and no the procedure which has been prescribed under the 140 is not followed, then auditor also can make an application to the tribunal under Rule 78 and can also make an application under Rule 11 for the justice, on the basis of justice, if no opportunity being given to the auditor. So manner of application NCLT 1, case law. In one of the case, the company has passed the resolution at the AGM and appointing another firm in place of retiring auditor firm and agreed with the procedure. The auditor moved before the NCLT. On the basis of that, the company has not given special notice, company has not passed the special resolution, considering not given opportunity and considering the same, and the company which has appointed the auditor, the said auditor from the partners of the said auditor, also the partners of the earlier auditor firm, and considering the same, also challenge the appointment of the auditor firm. And considering the same, the NCLT has admit the application and direct the company that to remain continue with the petitioner's firm till the next date of AGM, and if they want to not to continue, then in next AGM follow the compliances prescribed under 140 and can pass the resolution for the appointment of person other than retiring auditor. So this is the case. Also in another case, it happens that the company has passed the resolution not to expressly not to reappoint the retiring auditor, and after the AGM in board meeting, company has appointed the another auditor firm on the basis of casual vacancy. So this is all against the provisions of the Act, and considering the same, the agreed with the said procedure, auditor moved before the NCLT, and on the basis of that, company has not followed the procedure, not issued special notice, not passed special resolution, and also no casual vacancy question is arise. And considering the same, quest the appointment of the auditor firm and direct the respondent company to continue the petitioner firm and want to appoint another firm, then follow the procedure which has been prescribed under section 140 subsection 4 or 140 subsection 1, whatever the case the company wants to adopt. So this is all the case where the jurisdiction vested 140 subsection 4, where three applicant there, company, aggrieved person, if wants that company don't circulate the representation among the member or restrict the auditor not to read out the representation orally, then can make an application, and agreed auditor can also make an application where the company has not followed the procedure which has been prescribed under the provisions of Companies Act. So this is all the case where the jurisdiction of the tribunal prescribed, that is 140 subsection 4. Let's go for another section, and another section is 140 subsection 5. Another section is 140 subsection 5, where it states that without prejudice to any action under the provisions of this act or under any law for the time being in force, the tribunal either suo motu or an application made by the central government or application made by any person concerned, if it is proved that, if it is satisfied that the auditor of the company acted directly or indirectly in a fraudulent manner, indulged in any fraud, collude or abetted in any fraud in relation to or by to the company, officers or directors, then in such a case the tribunal pass an order and direct the company to change the auditors. And if the application is made by the central government, and if it has been satisfied the tribunal that the auditor is indulged in the fraud, then direct the company, direct the auditor not to function as an auditor, and direct the central government appoint another auditor in his place. Whatever the case, the auditor, the individual or firm against which the final order has been passed are restricted to act as an auditor for a period of 5 years. So this is the case. This is the section where the jurisdiction of the tribunal vested, that is where any person or on an application made by central government where it is proved that the auditor is indulged in the fraud, then in such a cases direction has been given to change the auditor. The manner of application is remain same, that is rule 78. The manner of application is NCLT 1. The supporting annexure, that is the document evidence which prove that the auditor is indulged in the fraud, and the mandatory supporting draft, affidavit, memorandum of appearance, all this. Now the case law. The well-known case law in this section is that, and that is ILNFS. In ILNFS, the Union of India moved before the NCLT Mumbai bench under section 140 subsection 5 for to change in auditors, in which the Bombay High Court, the writ petition has been filed by the Deloitte and in which the Delhi Bombay High Court upheld the constitutional validity of section 140 subsection 5 and states that 140 subsection 5 it's with regard to change in the auditor, but it does not speaks about the change in the past auditor, and that's why the remedy which has been prayed by the Union of India under the petition which has been filed under section 145 should not be allowed. So this is the case. Now another case. In one of the company, it happens that the company has issued prospectus, raised the money, and the purpose for which the money has been raised, the company has diverted the said funds for the other purpose, other than which the for which the fund has been raised and the same has been prescribed in the prospectus. As a result of which the sum of shareholders intimate the said fact to the ministry and demand the inspection in the company, into the affairs of company. And as a result of which the ministry has initiated the inspection, and the inspection report has been came out, and on the basis of which it was found that the affairs of the company mismanaged. Considering the same and considering the inspector's report and all these facts, considering the same, the NCLT passed an order and barred the auditor for a period of 5 years to act as an auditor. Agreed with the same, auditor moved before the NCLT, and NCLT, as considering the same, held that the 140 subsection 5 it's only on the basis of inspector's report, or 140 subsection 5 it's talk about where the auditor is entered in the fraud. Only on the inspector's report it has been proved that the affairs of the company has been found mismanaged, but for the same the auditor should not be proved that it is indulged in the fraud, and that's why the NCLT should not pass only on the basis of inspector report and the statutory audit has been prepared without books of account, without inquiry in the books of account. Only on that basis should not pass an order under section 145 against the auditor. So this is the case where the auditor is indulged in the fraud, then any person, central government may make an application to the tribunal, and tribunal direct the company to change the auditor. Another section where the jurisdiction of the tribunal lies in section 169, that is removal of director. That is similar removal of auditor, means procedure is remain same. Then under the removal of director is also the procedure. James Patient notice is required to be served by this requisites to members to the company. Company in turn intimate the same to the director who is to be removed, and he makes the representation and requests the company to circulate amongst the members, and the company is required to circulate the same, and if not circulate then give him opportunity to read out at the meeting. In this interregnum, if company or aggrieved person may make an application to the tribunal and restrict the company to circulate the representation and restrict the director to read out the representation orally in order to secure the needless publicity, that is defamatory matter. So the format of application and the rule prescribed for the same is Rule 79, under which it has been prescribed the format application remains in NCLT 1. The supporting draft here, that is the representation on the basis of which you are challenging that company's registration documents now, and the mandatory supporting draft. The case though, in one of the case, the company has directly called in a general meeting and passed an ordinary resolution for the removal of director, and has not followed the procedure. There is special notice and no opportunity being given to the director to be removed. Considering the same, the director moved before the NCLT under the Rule 79 and also under the justification rule, that is Rule 11. And considering the same, the tribunal quashed the resolution and direct the company, if want to remove, to reappoint the director, and if want to remove further, then follow the procedure. So this is all the case where the jurisdiction of the tribunal lies, that is 169 and 140 subsection 5, 140 subsection 4. Now another section where the jurisdiction lies, that is section 213. Another section where the jurisdiction of the tribunal prescribed, that is section 213, section 213. In the 213, it's all about where the tribunal pass an order for the investigation into the affairs of company. It prescribes the three circumstances where the tribunal pass an order for the investigation to the affairs of company. It's important to understand. In section 213, it prescribes that the tribunal, subclause A, the tribunal may, on an application made by requisite number of members, that is not less than 100 members or members holding not less than 1/10 of the total voting power in case of company having share capital, or in case of company not having share capital, one-fifth of the members whose name in the register of member, make an application to the tribunal on the ground that and praying that, seeking an order for the investigation into the affairs of company. So here the grounds and here the prayer is, final prayer is only to get the order for the investigation into the affairs of company. So this is one scenario. The another scenario where the tribunal pass an order for the investigation into affairs of company, that is on an application made to it by, that is made to the tribunal by other person, that is upper requisite number of member da, so other than that or otherwise. What does it mean by otherwise? And the third circumstance triggering here, otherwise means if the application filed in another section, that is section 241, 242, insolvency application filed, in which the tribunal satisfied that there are circumstances suggesting that, अगर ट्राइब्यूनल को लगता है कि ये सर्कमस्टेंसेस कौन से, तो ये रहा, द बिजनेस ऑफ द कंपनी इज बीइंग कंडक्टेड विद द इंटेंट टू डिफ्रॉड द क्रेडिटर्स, मेंबर्स or other persons, or the company was formed for a fraudulent purpose, unlawful purpose, or the affairs is in a manner oppressive to any of its member, or the business of the company is unlawful manner or a fraudulent manner. First. Second, the persons who are concerned in the formation or management of the company, affairs of the company, are found guilty of fraud, misfeasance, or other misconduct towards the company or towards a member. Third, the members of the company have not been given all the information which they are reasonably expected to be given, including the information with regards to the calculation of the remuneration payable to the managing director or other director, after giving a reasonable time of opportunity being heard. So after considering if the circumstances suggest, the tribunal, after giving the opportunity of being heard, parties pass an order and direct the central government to pass an order for the investigation into the affairs of a company and to appoint the inspector or inspectors in order to investigate into the affairs of company, and after that file and serve the inspector's report to the tribunal. So after which the central government under section 210 passed an order for the investigation into the affairs of company and appoint one or more inspectors. After the inspector's report, when it is found that the affairs of the company has been conducted in fraudulent manner, unlawful manner, formed for unlawful and fraudulent manner, and not given sufficient information to member, then in such a cases, the officers and directors involved in the said fraud, default, liable for action under section 447. So this is the case where the jurisdiction of the tribunal vested, that is when the affairs of the company are occurred in a fraudulent manner, and where on any application the tribunal suggesting that the circumstances exist that sought the investigation into the affairs of company, the tribunal may pass an order under section 213 and direct the central government by passing the order under section 210 appoint the inspector or inspectors. So this is the case where the jurisdiction lies, an important one. The manner of application is Rule 80, and that is NCLT 1, and along with that the supporting annexure are only those document evidence on basis of which it suggests that the investigation into the affairs of company required. So this is the supporting draft that are supposed to be made and compulsory supporting draft, that is, as you are aware about. Now the case law, this is important. In one of the case, what happened is that the company is a shareholder of another company, and the company has filed an application against that company in which is a shareholder under section 241 to 42. On the basis of that, the affairs of the company mismanaged. The ground is such that the company has issued minutes at various time, the same minutes at various time, and the said minutes are different in terms of agenda number, attendance, and body of resolution. And also the statutory report will be prepared, that is without inspecting the books of accounts. And also after filing an application, first the said application has been filed before CLB. The CLB needs interim order direct because applicant is also needed further information, but the respondent is not provided such information. That's why the CLB, by passing of interim order, direct the respondent to provide the information. Then the said information still not provided. So considering all this aspect, the information has not been provided. The minutes of the said meetings, the 2 minutes of the said meetings have showing different agenda number, different agenda, body of the resolution, and considering that it apparently shows that is a suspicious happening in the company. Not only the company has violated the provisions of maintaining and tampering the minutes, the provision of the tampering with the minutes, but also there is a circumstances exist that ought the investigation into the affairs of company. Considering the same, the tribunal pass an interim order and direct the central government to pass an order for the investigation into the affairs of company. Here the apparent, it shows that there is a circumstance suggests investigation ought in the affairs of company. The another case where the investigation order passed, that is in one of the case, it is important. The directors, in order to gain the control, voting rights, fraudulently issue the further shares without complying the provisions and increase their stake in the company. Considering the same, the aggrieved shareholders file an application before the tribunal under section 241 to 42, and in this interregnum, the directors also move for the selling of the property and willing to misutilize the property and misutilize the funds of company. Considering the same, the applicant move for the IA and pray for the relief of stay in the said action. And considering the same, the NCLT pass an interim order for the stay in the action, and status quo pass an order for the status quo, and also passed an order direct the CG for the investigation into the affairs of company, in order to know in what circumstances, in what manner the director has acted in a fraudulent manner, and what undue advantage the directors and officers have gained through mismanaged act. So this is the section and case law and rule where the jurisdiction lies, that is section 213, where the application made for the order suggesting that the investigation into the affairs of company required, and the tribunal in turn pass an order for the and direct the CG for the investigation into the affairs of company. So that is the case. Now another section where the jurisdiction lies, that is section 216. Another section, that is section 216, where the central government pass an order for the investigation into the membership, into the matters related to the membership of the company, and in order to find out that the following, in such a circumstances, central government pass an order for the same. But what it is, that is where the central government wants to decide that, want to know that who are or have been financially interested in the success or failure of the company, whether apparently or in reality, or who are or have been able to control or materially influence the policy of company, who have or had been beneficial owner of the shares of the company, or who are or have been significant beneficial owner of the company and have not reported. Then in such a cases, the central government pass an order and appoint one or more inspector under section 216 and investigate the matters relating to the membership, ownership of the company. Also, as we learn in section 213, the tribunal in any of the proceeding may also pass an order for the investigation and direct the central government for the investigation into the matters related to the membership of the company, ownership of the company. Then also direct the central government under section 216. Then central government pass an order under section 216 for the investigation into the matters relating to the membership and ownership of company. So this is the section where the jurisdiction vested to the tribunal, that is 216. The tribunal in any of the proceeding, if circumstance suggests that the tribunal may pass an order and direct the central government to pass an order to appoint the inspector for the investigation into the matters related to the membership and ownership of the company. The another section where the jurisdiction of the tribunal vested, हमने 213 देखा, 216 देखा. Now section 218. Section 218, which prescribes that notwithstanding anything containing any other law for the time being in force, if during the course of an investigation of the affairs and other matters relating to the company, other body corporate or person concerned, whether it is under section 210, 212, 213, 216, 219, or of membership or other matters of relating to the company or ownership of the shares in the company, body corporate, other person, that is under section 216, and during the said proceedings and investigation or any proceedings during the which has been initiated under this chapter, inspection, investigation and inquiry, then during the said proceedings, if any body corporate, any company or any person wants to take the proposed action, that is discharge or suspend any employee or punish him, whether by way of dismissal, removal, reduction in rank or otherwise, or to change the terms of the employment to his disadvantage, then in such a cases, before taking such action, they need to require to take the approval of tribunal. And the tribunal, if not raise any objection within period of 30 days, then the company, body corporate or other person may move before the proposed action. But if taken, then they are restricted to take action. And if they are disagree with the same, they can make an appeal within period of 30 days from the receipt of objection to the appellate tribunal. So this is the another section where the jurisdiction of the tribunal vested, where during these proceedings which is initiated under this chapter, if any person, body corporate or company wants to take action, that is to remove an employee, to discharge an employee, to suspend an employee, to reduce the promotion, rank in the to change the terms of the agreements of the employee, then in such a cases, for the same, the company first needs to require to take the approval of tribunal. And if tribunal raise objection within 30 days, then they can't. And if not raise objection within 30 days, then they can do and they can move forward. The another section where the jurisdiction of the tribunal vested is section 221. Section 221. Important. Where it appears to the tribunal on a reference made to it by the central government or in connection with the inquiry, investigation into the affairs of company under this chapter, or on any complaint made by such a number of members which are specified which are eligible to file an application under section 244, and that is 100 members or 1/10 of the members whichever is less or member holding 1/10 of the issued share capital, such a member or any complaint or a central government or in connection with the investigation inquiry into the affairs of company or creditor having a 1 lakh rupees outstanding against the company or any person having a reasonable grounds to believe that removal, transfer or disposal of funds, assets and properties of the company is likely to take place in a manner that is prejudicial to the interest of company or its shareholders or creditors or in a public interest, it may by order direct that such a transfer, removal, disposal shall not take place during the period of 3 years or if take place with such restrictions as may prescribed. So, Section 221, it's all about 221. Section 221, it's all about कि wherever the reference has been made to the tribunal by central government or in connection with the inquiry inspection, complaint has been made or members which are eligible to file an application under Section 244, any of them can make an application and show that the transfer, dismissal or removal may take place of the funds, assets or property of the company which is likely to take place and which harm the interest, which is prejudice to the interest of company, public interest and members interest, then tribunal restrict the company from doing such an act for a period of 3 years, or if company willing to do, then also further put a restriction on the same. Section 222 उसी तरीके से है कि where it appears to the tribunal in connection with any investigation under Section 216 or on a complaint made by any person in this behalf that there is a good reason to find out the relevant facts about the securities issued or to be issued by a company, and the tribunal is of opinion that such a facts cannot be found out unless the certain restrictions as it may deem fit are imposed. The tribunal may by order direct that the securities in a question is further subject to restriction as it deem fit for a period of 3 years, not exceeding 3 years as may be specified in the order. So wherever the tribunal reference has been given to the tribunal with regards to the securities issued by the company that harm against the interest of company, then in such a cases the tribunal put a restriction on the exercise on such a securities so that no right attached with the securities are utilized. Till the date it has not been proved. So this is Section 222. Section 224. Section 224, it says that if any company or body corporate is liable to be wound up, it generally says that when it appears to the central government during the investigation, inspection or from the inspector report that the company and body corporate is liable for the winding up and is also eligible for the winding up, then central government on behalf of the central government may make an application to the tribunal for the winding up of the company on the ground that it is just and equitable that the affairs of the company be wound up. On the said grounds, the petition for winding up of the company may be filed by the central government after analyzing and after during the investigation find out that the affairs of the company ought to be wound up. Then central government may make an application and may refer to the tribunal under Section 224. But it should be out of the investigation and inspection. So this is the case where the jurisdiction lies. So we have gone through in last Section 213, Section 216, Section 218, जहाँ पर एम्प्लॉय के ऊपर कि अगर आप एम्प्लॉय की ड्यूरिंग द इन्वेस्टिगेशन इंस्पेक्शन एम्प्लॉय के खिलाफ कोई एक्शन लेना चाहते हो तो ट्राइब्यूनल का अप्रूवल 216 में हमने इन्वेस्टिगेशन इनटू द मेंबर मैटर्स रिलेटिंग टू द मेंबरशिप और ओनरशिप ऑफ द कंपनी, 213 में हमने देखा इन्वेस्टिगेशन टू द अफेयर्स ऑफ कंपनी, 218, 213, 216, 218, 221 कि जहाँ पर restrictions on the transfer, dismissal and removal of the assets, funds of the properties of the company may also put by referring to the tribunal under section 221, सेक्शन 222 जहाँ पर सिक्योरिटीज इशू किया उसके ऊपर रिस्ट्रिक्शन ला सकते हो, एंड सेक्शन 224 कि जहाँ पर सेंट्रल गवर्नमेंट ड्यूरिंग द इन्वेस्टिगेशन, इंस्पेक्शन एंड आफ्टर द इंस्पेक्शन फ्रॉम द इंस्पेक्टर्स रिपोर्ट अंडर सेक्शन 223 if found that the affairs of the company ought to be wind up, then may make an application for the winding up if the company is eligible. So this is a case where the jurisdiction of the tribunal vested. The another section where the jurisdiction of the tribunal vested, and that is section 230. The another section, that is section 230, where the jurisdiction of the tribunal vested. Now the sections relating to the compromise arrangement and the section relating to the amalgamations and merger compromise arrangement chapter, and the sections relating to the operation mismanagement, for which the separate session required for both of it, and that's why the same will be dealt by another part. Apart from those sections, now let's move forward for the other sections. So the another section where the jurisdiction of the tribunal vested is section 248 subsection 8. Section 248, it's with regards to the removal of name by the registrar on voluntary application or by the registrar suo motu, in which section 248 subsection 8 states that nothing in this section shall affect the power of the tribunal to wind up a company, the name of which has been struck off by the registrar. Here it says that even the name of company which has been struck off by either ROC or by the company voluntarily, but the power of tribunal remain vested to wind up the company even though the name of which has been struck off. This section and the power has been given because of, in certain cases, what happened is that the company, in order to evade the liability, in order to deceive the creditors, make an application for the strike off, and the ROC strike off the same, but the creditors' interests remain undischarged, and that's why the creditors agreed with the same, may make an application before the tribunal for winding up of the company, for the order of winding up of the company. So that's why the power of tribunal remain vested, and nothing in this section 248 applies to the power of tribunal to wind up the company, the name of which has been struck off. The another section where the jurisdiction of the tribunal vested, that is section 252. Section 252, it's all about the restoration of the name of company in the Register of Companies maintained by the Registrar of Companies. Under section 252, there is two subsections, two separate manner of application, two separate grounds of the manner of application, but the purpose is remain same, that is restoration of the name of company in the Register of Companies by the Registrar of Companies. Section 252, subsection 1, where it prescribes that any person, here the any person word is there, aggrieved by an order of the registrar notifying a company as a dissolved under section 248 may file an appeal to the tribunal within a period of 3 years from the date of order of the registrar, and if the tribunal is of opinion that the removal of the name of company from the Register of Companies is not justified in view of the absence of the ground on which the order was passed by the ROC, it may order the restoration of the name of company in the Register of Companies. So here what it says that any person may make an appeal within a period of 3 years from the order of registrar if the said person is aggrieved with the order of registrar. The ground is the registrar has removed the name of the company on the absence of the ground, on the irrelevant ground, and then in such a cases the tribunal, after considering the same, pass an order for the restoration of the name of company in the Register of Companies, provided that before passing an order, tribunal shall give the reasonable opportunity of being heard to the party, to the registrar, and to the person whom file an appeal. provided further that, and here also provided further that if the registrar is satisfied that the name of company has been struck off from the Register of Companies either inadvertently or on the basis of incorrect information furnished to the registrar while making an application for the striking of the name of company, then registrar may also make an application within a period of 3 years to the tribunal for the restoration of the name of company, so that the interest of the stakeholders remain protected. Now, there is section 252, the manner of application in which the application should be made. There is no separate rule under the NCLT rules 2016 which prescribe the separate manner of application for the section 252(1), and that's why the general rule, that is rule 88, where the general application format of application prescribed, and that is NCLT 9. The supporting annexure here is the registration document of company, the notices which has been issued to the company for striking off by the ROC, the master rate of the company which shows the strike off of the company, the proof showing that the company is operative, and registrar's grounds on the basis of which it has been strike off it is absence of ground and is irrelevant, that is financials of the company on the basis of which you can prove property related documents, list of shareholders, list of creditors, affidavits, some affidavits which are required, that is affidavit regarding affidavit verifying application, additional affidavit showing that the status of director, status of company, and the demonetization, the transaction which during the period of demonetization. Now, at the first hearing, the direction given to serve the copy of application to ROC, and after receipt of ROC report or ROC and income tax, in some of the cases the practice has been adopted, income tax and company and appellant, after hearing all the parties, the tribunal pass an order for the restoration of the name of company. So under section 252(1), the ground is 3 years. Within 3 years, any person can make an application, and the ground is the company. On the absence of the ground, the ROC is struck off. The case law is, in one of the case, what it happens that the company has been incorporated in the years of 2014, and because of non-filing since the incorporation, the ROC has strike off the company in the year of 2018. But at the year of 2018, the company was remain operative, and ROC is strike off because no annual return has been filed. The ROC is of assumption that company is not carrying on business, and considering the same, ROC has strike off the name in the year of 2018. Agreed with the same because the company was remain operative and company willing to operate, and that's why the one of the member made an application appeal under section 252(1) in the year of 2020-21 because it has not been passed, and here the absence of ground is there because the ROC has strike off the company on the basis of assumption that the company is not operative, but the company is operative. Why? Because in 2018 the financials which are attached with the application proves that there exist in the financials in the year of 2018 the borrowings, long-term borrowings, short-term loans and advances, trade payables, investments, and which shows the companies remain operative. The company was operative at the time where ROC has strike off the name, and that's why, considering the same and considering the ROC report, the tribunal has passed an order for the restoration of the name of company in the register member, but subject to condition that to pay the penalty to defray the expense which has been incurred by the ROC for strike of the name. Second, to make the compliances fulfilled, that is, file the due annual returns and documents which are due. So, subject to the order has been passed. So this is the case where the jurisdiction of the tribunal vested, that is section 252(1), where the time limit has been prescribed, that is 3 years. Any person can make an application, even registrar may also make an application and pass an order where the in absence of the ground, ROC has strike off the name. Now section 252(3), it's wider section 252(3), which cover all the possibility for the restoration of the name of company. Let's move forward for the same. Section 252(3), where it prescribes that if a company or any member or a creditor or workman, creditor, member, company feels aggrieved by the company having its name struck off from the Register of Companies, the tribunal on an application made by company, workman, member or creditor before the expiry of the 20 years from the notice issued in Official Gazette, that is asterisk 7, if it is satisfied that tribunal that the company was at the time when the name has been struck off carrying on business or in operation, or otherwise it is just that the name of company be restored to Register of Companies, order for the restoration of the for the name of company to be restored to the Register of Companies, and the tribunal may by order give such other direction and make such provision as deemed just for the placing the company and all other persons in the same position as nearly as may be as if the name of company has not been struck off. So 252.3, where a company, member, workman, creditor make an application within a period of 20 years on the ground that at the time of striking of the company was in operation and business, or otherwise it is just that the name of company to be restored. So what will be the case? The manner of application remains same, that is General Rule 88, and that is format of application NCLT 9, and the annexures that is remain same, the particulars of registration documents, supporting evidence which shows that company was in a operative property related document, and the ground here is otherwise deemed just that. What did deem just that? If the company is not operative, in one of the case what happened is that the company is incorporated in the year of 1995, and the company has failed to file the return of 2004-5-6. As a result of it, the ROC has strike off the company in the year of 2010. Now, but at the time of striking off, even the company is not operative, but the company have the property, or the company have the liabilities, and the members or directors want to restore the company because to sell out that property, or because to discharge the liability, because in order to safeguard the interest of directors, members from the further prosecution, and that's why they move before the tribunal in the year of 2021, that is after 10 years. So after considering the application and ground, it shows that it is just deemed fit that because in order to sell out the property, in order to repay the liabilities and borrowings, there is a need to requirement to restore the company. Unless the company is in existence, company is not in position to sell the property or pay out the liabilities, and that's why it is necessary to restore the name of company. So the tribunal considers the same, and it is always beneficial to restore the company from the point of view of the tribunal, from the point of view of the ministry. Why? Because by restoring the company, the order is whenever the tribunal pass an order for the restoration, it always also bind the obligation of to make the compliance done, whatever the compliance due, and that's why it is always beneficial for the ministry to restore the company and for the tribunal to restore the company, and that's why the majority of the restoration application are admitted and passed. So considering the future liabilities and considering the liabilities pending and considering the properties exist in the name of company at the time of when the liability is struck off and still it is in existence, that's why the tribunal pass an order for the restoration of the name of company in the Register of Companies. So this is the case where the restoration of the tribunal vested, that is section 252.1, section 252.3. The difference is here any person can make 3 years period, registrar also make an application, absence of ground is there. Here it is otherwise just deemed fit that ground also, that any other ground or 20 years period, member, creditor, workman and company may file an application. Now the another section where the jurisdiction of the tribunal vested, and that is section 441. Section 441, it's all about the compounding. as we are about the compounding offence, the offence which are compoundable, that the offences, the such offences which are punishable with the imprisonment only or imprisonment and fine, such offences are not compoundable offence. Other than that, the offences which are compounded, for to compound the offence, before the initiation of prosecution or after the initiation of prosecution, you can compound the offence, and for that first you need to make an application to ROC, and then ROC, after reviewing the same, refer the matter to NCLT or RD as the case may be. If the penalty amount and compounding fee is up to 25 lakh, then matter is referred to the RD. If above, then matter is referred to the NCLT. So the format of application here is remain same. That is no specific rule is there for the same, and that's why the manner of application is 79. And here the supporting document is the registration document of the company, the proof with regards to the non-filing of the same, the proof with regard to the filing of the same, and document evidence why it is not been filed. After considering the same, the tribunal pass an order and compound the offence. While compounding the offence, the tribunal shall take into consideration that the penalty which has been prescribed under the Act, the minimum penalty, the compounding fee should not be less than that. Now, the case law. In one of the case, what happened is that the company has violated the provision of 383A of the Companies Act 1956 and Section 203 of the Companies Act, right with Section 203 of the Companies Act 2013. What happened is that the company has failed. The company has not appointed the whole time company secretary since 1/4/2009 से कंपनी ने कंपनी सेक्रेटरी अपॉइंट नहीं किया था. 2009 है इसलिए 1956 आएगा, एंड 2000 अभी तक नहीं किया, अभी एप्लीकेशन करी 2020 में, तो दैट्स वाई आफ्टर 2014 कंपनीज एक्ट 2013 आएगा. सो 1/4/2009 में कंपनी ने अपॉइंट, 1/4/2009 से कंपनी ने अपॉइंट नहीं किया था और कंपनी ने अपॉइंट किया 2018 में. सो आफ्टर 2014 द एक्ट इज 2013. So here the compounding of both the section are required, that is 383A and 203, and that's why the application has been made before the NCLT, because the fine amount is beyond 25 lakh. Considering the fine of company, directors, 2 directors and officer in default, in short. So the tribunal has considered the penalty which has been prescribed under section 383(1)A for the period, that is 1/4/2009 से लेके 31/3/2014 and 1/4/2014 से लेके 1/4/2020/3/2018, and the penalty which has been prescribed under section 383A is that 1 lakh 100 rupees per day from 1/4/2009 to 30/3/2014 for company and the applicant, that is direct officer in default. And under the Companies Act, that is 2013, this is section 203, the penalty which has been prescribed, and that is 1 lakh fixed for the company and 200 rupees for the each directors, 10,000 fixed, and 200 rupees per day for each day for each directors from the period of 1/4/2014 से लेके 20/3/2018. So tribunal, after imposing such penalty, passed an order for the compounding, and the offence has been compounded but subject to payment of the compounding fee. The said compounding fee and said compounder need to require to file with the ROC within period of 30 days in a form INC 28. And as per the direction, the company is to require, applicant is to require to pay the compounding fee. Now the another section and the intrinsic section, last section where the jurisdiction of the tribunal vested, other than that operation mismanagement and merger amalgamation compromise arrangement, that is section 442. Section 4, another section where the jurisdiction of the tribunal vested, that is section 442, where the central government, where it has been specified that the central government shall maintain the penal experts of panel that is called mediation and conciliation panel, containing such a number of experts and having such a qualification as may be prescribed, as may deem fit by the central government, for the mediation and conciliation in the proceedings, in any of the proceedings between the parties going on before the central government or court or tribunal or appellate tribunal under this act. So this is important. Any of the parties to the proceedings may at any time during the proceedings before the central government or before the proceedings that is going on before the central government, before the tribunal, before the appellate tribunal, if they willing to refer the said proceedings or matter covered under the proceedings to the mediation and conciliation panel which has been constituted by the central government, then apply to the same to the said authorities, then the said authorities refer the said proceeding to the experts from the mediation and conciliation panel, and the expert is also selected by the parties themselves from the panel. And for the selection, the authorities also help of them. Not only parties, the tribunal, appellate tribunal and central government also suo motu can also refer the proceedings to the experts from the mediation and conciliation panel. So this is one of the important concept, and the manner of application is NDC2, mediation and conciliation panel, NDC2, for the referring the matter proceedings going on before the central government or tribunal, appellate tribunal to the mediation and conciliation experts. So this is one of the section where the jurisdiction vested, and this is one of the interesting provision which has been introduced under section 442. So that's it for the day. All the sections where the jurisdiction of the tribunal has been covered except the section that is section pertains to operation mismanagement, pertains to the tribunal, winding up of tribunal, constitution of tribunal, appellate tribunal, that I will not be considered, and operation mismanagement and winding of tribunal and compromise management. For that separate session, separate part is there. Till that, stay connected, and if you like this video, then don't forget to like and subscribe my channel for to remain updated with new upcoming videos. So till that date, stay connected, stay safe and stay happy. And once again, I would like to cover whatever the sections that we have gone through in this session. And the section that is we have gone through, that is section 140 subsection 4 से शुरू हुआ था, 140(4), 140 subsection 4, 140 subsection 5, 140(4), 140(5), उसके बाद then after we have came to section 169, section 213, 213 से शुरू हुआ 213, 216, 218, 221, 222, 224, and then we have gone through section 248, 252, 252(1), 252(3), and 252(3), and section 444 compounding offence and 442. So that's it. Stay connected, stay happy and stay safe. Till the time, goodbye.